Hello and welcome to Coin Lady channel. The question is whether or not Ripple can win against the SEC. When will Ripple offer up some fresh justifications? When the free trial period ends, how much will it cost to continue to exert? In today's video, we'll discuss these issues and more. As for now, all you have to do is subscribe to the channel. After a lengthy hearing between LBC and the SEC yesterday in the war and B room of the United States Courthouse in New Hampshire, Attorney Deaton prevailed decisively on behalf of LBC token holders and the entire crypto sector. In order to prevent the judge from providing clarification for LBC, Deaton, representing tech journalist Naomi Brockwell as her Michi counsel, successfully argued that secondary market transactions involving LBC are not securities. LBC, the company's management, and the general public are all treated equally in the SEC's suit and injunction. During oral arguments, Brockwell's attorney, Deaton, noted that the injunction was too vague and overbroad, prompting him to seek clarification on behalf of his client and other LBI users. LBC trading in the secondary market. When asked where he got his ideas for crypto law, the man who created them said they came from a paper written by commercial contract lawyer Louis Cohen that reviewed every security case in the US after Huawei. Cohen's investigation into US security cases, as recounted by Deaton, allegedly revealed that no court had ever ruled that the underlying asset was in fact a security. Deaton said to the judge, "It appears from the article that you are implying that LBC is security in and of itself. We need to explain it if you don't mean for that judge to rule that way." After some back and forth, according to Deaton, the judge has indicated that he does not plan to issue an injunction. He continued by saying that the court's decision not to issue an injunction against LBI users was a huge victory. According to Deaton, he was successful in having the SEC go on the record as saying that LBC's secondary market transactions are not securities. Discussing Alberry at a hearing the risks involved in trading any form of cryptocurrency. A number of Bitcoin supporters, including Ripple V, have tweeted their admiration for Eaton's work on the BI case, suggesting that it could be used in future cryptocurrency-related matters. Attorney Jeremy Hogan of the Hogan law firm applauded Eaton for pressuring the cult to officially state that LBC is a token and not a security. At the SEC's ultraviolet LBC hearing, the SIC stated for the record that the token itself is not a security. A plus performance. Hello, Mr. Deaton. Also, Alina Barrett, a Fox business reporter, has lauded Eaton, calling him the hardest-fighting advocate for the Bitcoin sector. Eaton is the man responsible for the development of crypto law. In the Hale-Bracken case, takeaways prevailed. The group of lawyers told the author that buying and selling loyalty tokens on the secondary market does not make the tokens a security. John is unparalleled in his commitment to the security industry as a whole. When you take him out of the equation, the SEC's job becomes much easier. The following is a message from Aubrey to SIG, sent in the form of a SIG-friendly ideal. Ripple's general counsel Stuart Calderon has responded to a Bloomberg article titled "Fight to Regulate Crypto at Crossroads as Ripple Ruling Looms." The article, which was published yesterday, explains how a ruling in the upcoming Ripple v. SEC lawsuit will decide whether the SEC or the CFA should regulate the industry at the federal level. According to Bloomberg, the answer, along with the futures of many crypto investors and companies, could be determined by an upcoming ruling in New York federal court regarding the lawsuit between the SEC and Ripple. In this case, the outcome depends on whether or not a well-known digital token should be considered a security, thus coming under the purview of the Securities and Exchange Commission. According to XSEC's lawyers quoted by the major media, the outcome of the Ripple lawsuit will depend on the collapse of cryptocurrency exchanges. Al Dowry commented on the article, saying, "In spite of Bloomberg's analysis, cryptocurrency experts agree that the case has far-reaching implications for the future of digital currencies in the United States." He said that the outcome of the Ripple case will likely have a major impact on the future of crypto in the U.S. No matter how you look at it. The ongoing Ripple case has captured much attention from the XRP community and other cryptocurrency investors, thus suggesting the significance of the lawsuit in the US crypto industry. Leading figures in the crypto industry, such as Ripple's CEO Brad Garlinghouse, have been debating whether or not the European Central Bank, ECB, or some other international body should step in to regulate the sector. Under Gary Gensler's leadership, the SEC is making an effort to cast itself in the role of the emerging markets enforcer. Should the SEC prevail in court, according to Carol Garforth, a professor at the University of Arkansas School of Law who specializes in fintech regulation, the regulator will assert jurisdiction over most crypto assets, as reported by Bloomberg. A victory for Ripple, however, could weaken the SEC's position as cryptocurrency's primary regulator. It is worth noting that the SEC's regulatory approach to cryptocurrencies has been met with criticism from industry participants. Aldo Brody and others in the industry have accused the SEC of putting an emphasis on enforcement rather than elaborating on the rules. Former SEC attorney and crypto enthusiast Arthur Jacoby has criticized the SEC's approach to crypto regulation. Jacoby pointed out that the SEC has chosen to establish its jurisdiction over digital assets through the federal court system, rather than through open and public rulemaking that incorporates industry comments. Gensler has responded to these concerns by saying the rules of the financial market are already crystal clear. Both the SEC and Ripple have asked Judge Annalisa Torres to rule in their favor in the ongoing lawsuit, and a ruling is expected to be handed down sometime in the first half of the year. Ripple and the U.S. Securities and Exchange Commission's protracted legal battle appears to be winding down. Top U.S. Defense Attorney James K. Filing tweeted to his over 138 followers today that as of January 19, 2023, the lawsuit has been fully briefed. This indicates that both Ripple and the SEC have filed the necessary documents, such as a motion for summary judgment and a motion to seal all materials related to the summary judgment motion. This tweet is part of a larger initiative to keep the XRP community abreast of developments in the case's scheduling. A snippet of the image attached. For the time being, we must wait. While waiting for a final decision, Judge Annalisa Torres is reading through the numerous briefs submitted by the parties. Community members responded to the tweet excerpt by thanking Fallen for keeping them informed throughout the lengthy legal battle that has lasted for over 2 years. Jeremy Hogan, a partner at the law firm Hogan Hogan, is one of many in the crypto community who have thanked Fallen for his work keeping them informed. Attorney for the X-Sharp community John Deaton also responded to Fallen's latest schedule update. Deaton praised Fallen's most recent tweet about the Ripple v. XX lawsuit as the best update so far. The SEC sued Ripple and two of its executives, Brad Garlinghouse and Chris Lawson, in December 2020, sending shockwaves through the cryptocurrency industry. Allegations from the SEC state that Ripple and its executives peddled unregistered securities in the form of bonuses. Forbes has called this case the cryptocurrency trial of the century, and it is widely anticipated to establish a precedent for the future of the U.S. crypto market. If Ripple prevails, it could help clarify U.S. regulations. But if the SEC wins in court, the regulator will have a powerful tool to use against other cryptocurrency projects. Recent filings indicate that Judge Torres is likely to issue a ruling on the case by the end of March 2023, which is earlier than previous projections. Meanwhile, Ripple's CEO recently revealed to Campisi that he anticipates a final resolution of the company's legal brawl with the SEC to occur in the first half of this year. According to Garlinghouse, Ripple is in a strong legal position, so he has no doubts about the outcome. The judge has received all of the briefs in this case. At the very latest, we expect this to be settled by the middle of 2023. What happens next will be interesting to watch. But I am confident that we are in a good spot legally and factually, he said. The Crypto Basic in Davos reported that Ripple company claimed that the public would be shocked to learn of Hyman's sexist emails. It's all over today. Please like and subscribe my channel. See you later, bye.